dive right into the content here this morning. Um, Cooper and I are here to speak about really two, somewhat unrelated topics, but two really important, I'll say really hot topics for employers in Halton and Peel and York region these days. First is disability management, and Cooper will bring you through that topic. We'll go through the agenda in a second to talk a little bit more about what we'll be covering specifically, but we'll be talking about that broad issue of disability management. That's the idea of accommodating employees with disabilities. It's a complicated area. There are employment standards considerations to think about. There's human rights considerations, of course, that you need to think about. And there's operational, considerations you need to think about as well. And in some cases, you need to balance all of those considerations with health and safety, with cost. It's dizzying, I know, but we're going to try to cut through some of the confusion for all of you here and really give you some key useful information and insights that you can all take back to your organizations and hopefully equip you better to manage these situations next time one comes up, because I think we all know that these situations are coming up more and more frequently as the years pass, as a lot of the stigma associated with accommodation requests is going away, and as employees are being more confident in bringing these requests forward. It results in more requests for employers and more complicated issues to deal with. And then from there, we want to talk about tariff-related workplace considerations and just the broader economic downturn that I think I think it's clear at this point that we're facing, and some of the impacts that may have on your organizations and some of the things that you can do now to help get ready, to prepare for potential impacts of the economic downturn and the tariffs, to make sure that you can mitigate the impact on your organizations, retain as much of your workforce as possible, and minimize the costs that you may face as a result. So you've already got the intros to both of us. I won't spend any more time there. And I'm just going to bring us over to the agenda before passing it over to Cooper. So within disability management, Cooper is going to cover some basic principles of accommodation. It's always useful, I find, in these presentations to really level set for everybody. Let's make sure we're all on the same page in terms of what does disability management entail? What does accommodation entail? So we all have those fundamental concepts clear as we get into a little bit more of the applying those concepts to how it works. We'll then talk specifically about how you can go about requesting medical information, some legal developments, so some recent case law that really helps to understand some of these concepts that we're going to be talking about, understand how adjudicators in Ontario are applying these concepts these days. And then we're going to speak about remote work requests from there. Going forward, I'm going to be covering the tariff considerations, and so we'll be talking about some of the recent changes to EI and other government programs that are available to organizations right now to help mitigate the impacts of the tariffs and the economic downturn that we're facing. And then I'll be talking about some of the tools that you do have at your disposal and how to get ready to take advantage of those tools. And that includes temporary layoffs and terminations of employment. I'm going to talk in that area about termination clauses specifically and what that means, what that means for employers so that you can ensure you're ready. And so again, without further ado, I'm going to pass it over to Cooper to talk about disability management.
Thanks, Joel, and good morning, everyone. I'm really excited to be here with you all. So we'll start out with a really important topic, that's disability management. I know a lot of you are excited to hear about it, and that's because accommodation is a challenging issue for employers to manage. As Joel noted, employees are becoming increasingly comfortable requesting accommodations. It's definitely a trend we've seen in our practice over the last several years. There's more and more accommodation requests every year, and I'm sure a lot of organizations here can empathize with that, and they have personal experience with that as well. So I'm going to talk about a few key things, as Joel noted, some fundamentals about accommodation, the case law developments, and then we'll apply these principles to remote work requests. So for some basic principles about accommodation, at a high level, employers have a duty to accommodate, but what does that really mean? I think a great way to learn about this is through a conceptual difference between discrimination on the one hand and accommodation on the other. Discrimination, as many may know, involves treating an employee differently based on a protected ground under Ontario's Human Rights Code. That conduct is strictly prohibited and employers are not permitted to engage in discrimination. On the other end of the spectrum is accommodation, and that can be a bit trickier to understand, but it doesn't have to be. Accommodation, the duty to accommodate, is triggered by an employee's limitations that relate to a human rights ground. That could be disability, for instance. If the duty to accommodate is triggered, Employers have a duty to modify the work arrangement with the goal of fully allowing the employee to participate in the workplace to the best of their abilities and subject to those limitations. Some examples of typical accommodations include remote work, which we'll talk about more in more detail later on in this presentation, but also, for example, a standing desk, maybe adjusted work duties, or a medical leave. And just to camp on medical leaves, because they're a slightly more complex form of accommodation, a medical leave can depend based on the specific workplace. There are base level entitlements under the Employment Standards Act in Ontario, but each workplace is different. For example, if a workplace is unionized, might be a collective agreement that speaks to other relevant medical leaves that would enhance an employee's entitlement. Similarly, an employment contract might speak to medical leave or workplace policies, and these are all important to consider when assessing whether to provide an accommodation, especially in the context of a medical leave. The employment relationship and the duty to accommodate tie together because a lot of organizations think, well, the duty to accommodate just relates to the performance of typical workplace duties. And in many instances, that might be the case, but it's not all of them. The duty to accommodate applies throughout the life of the employment relationship, and that starts with the hiring process before an applicant is even hired as an employee. We'll talk about a case later on, which relates to the job interview. And employers have a duty to accommodate even at the outset, right at the job interview. Similarly, another less talked about aspect where the duty to accommodate applies in the employment relationship is during workplace investigations. The same duty applies there to employers and workplace investigators, where employees may require an accommodation in the form of frequent breaks during a workplace investigation interview, or if they need to provide their answers in writing. And that duty to accommodate applies all the same. So when an employer will receive a simple request, their instinct might be to accept it on its face, and we'll talk a bit about some of the best practices with more straightforward requests as well. But when there's a challenging request, it's easy to see how an organization might ask, can we just deny it outright? What are the steps involved in that? And it's more complex because the standard that organizations are held to is the standard of undue hardship. That means that organizations are expected potentially to accept some amount of hardship to provide an accommodation to an employee. The threshold is it just cannot be undue, and that's with three factors: cost, health and safety, both to the employee and the workplace more generally, as well as funding. And just to round out some of these initial basic principles of accommodation, the standard for accommodation, what is it? It's difficult for some organizations to assess what standard are we going to be held to, but the recent case laws we'll talk about more later on it's a standard of reasonableness. Organizations don't need to be perfect. They don't even need to provide the precise accommodation that an employee prefers or that they've requested. The accommodation provided simply needs to be reasonable. Reasonable in the sense that it actually addresses the employee's workplace limitations and allows them to participate. Moving on now to some other principles of accommodation, we can think of the duty to accommodate with two coexisting duties. We can break it down into these two parts. There's the procedural duty and the substantive. So starting with the procedural, if an organization is aware that an employee has a disability, for instance, and specifically if they are requesting an accommodation, they have a duty to ask for relevant information. You should be asking clarifying questions if the information you have is not sufficiently detailed. In considering all the information available, then the organization can procedurally look at the request and the need for accommodation. They can look at the wider organizational context, and they can assess whether to just grant the accommodation request. That might be acceptable. Or if they can't accept the request as is, are there alternative arrangements that would still reasonably address the workplace limitations? Um, Something else that's important to note about the procedural duty to accommodate is that even if an employee doesn't make a request, but they still have a disability or the employer has a reasonable suspicion to suspect that the employee might require an accommodation, employers actually have an active duty to inquire. They have a duty to ask the employee about, do you have workplace limitations in the sense that can we provide an accommodation to you to help with some difficulties? This is trickier, but it's still part of the general procedural duty to accommodate. And to better understand and conceptualize what the procedural duty looks like for organizations on the ground, a lot of this will involve documentation. That's a best practice, is to record the steps you've taken to receive the request, or what information you know, what information you've additionally requested to consider what the accommodation might look like in practice, and really create a paper trail. Early on in the accommodation process, both parties, the employee and the employer, might agree on what the accommodation is just because the employee requested it and the employer thinks that it's simple to provide. But as I've said, it's a best practice to ask for more information because if you've created this documentation and a record of all the steps you've taken, later on when an accommodation becomes more complex or when you realize what the actual implementation looks like, you'll have all of these documents and records to show that you've fully engaged with the accommodation process and that you've discharged your procedural duty. With the substantive duty to accommodate, this might be more what an organization typically associates with the duty to accommodate. It's the determination on a case-by-case basis of what the actual accommodation will look like. Here, we're looking at, does the organization address the employee's unique needs? Do they provide that reasonable accommodation? And in the event that they're going to deny the request, what's the basis for doing so? Have they reached the threshold, the very high threshold of undue hardship? Another reason for denying an accommodation request would be that the accommodation directly contravenes with what is called a bona fide occupational requirement. This is the employer's burden to show, and it's just to show that the requirement of the job is necessary to accomplish a workplace expectation, and for whatever reason, the accommodation inherently contradicts that. And so by looking at these two coexisting duties to accommodate, employers can understand generally what the actual day-to-day implementation of that will look like. Um, Moving just a bit now to the case study, I want to give an example of what this will look like in practice because in our experience, we've assisted lots of clients with different accommodation requests. But just putting all these principles together, it's easier to understand in that way. So we've had clients with varying accommodation requests, and even one where a client had an employee that didn't like working with their manager. The dispute was so significant that the employee took a leave. They eventually returned to work and got a medical note, specifically not to work with their manager. And this was obviously a problem it would be for any organization, but specifically our client because the manager was the head of the department. There wasn't anyone else to report to. We've guided the client and we instructed them to ask for more information from the doctor regarding the nature of the contact that would be allowed between their employee and the manager, but the doctor clarified that there was no contact, no arrangement would be permissible. And so the other option for our client was to allow the employee to directly report to the CEO, but given the low level title that the employee had and the role within the organization, it wasn't operationally feasible. So we advised our client to assert undue hardship. That isn't always certain. Every case is fact specific and case by case basis, but our client had a strong position here given all the information available to it. And by looking at that case study, it really talks about all the steps that we've discussed in terms of the basic principles. The employee had a request for a leave. That's a request for an accommodation. Our client considered it and granted the accommodation. The employee requested to not talk to their manager when they returned to work. That's yet again another accommodation request. Our client needed more information and they sought that from the doctor, and the doctor confirmed that the alternate arrangement wouldn't be okay for the employee given their limitations. Our client assessed, they considered alternatives, as I mentioned, reporting directly to the CEO, but they weren't feasible. And as a result, they asserted undue hardship because the cost to create a new role specifically to manage the employee would have been so prohibitive that it would have represented undue hardship. And typically, in the context of disability and in accommodation, employers aren't going to be expected to create new roles or new work just to accommodate. So you can see how that case study would directly coincide with the need to request for medical information, because we've talked about the first steps of accommodation. We've talked about triggering the duty to accommodate. Um, but now when you actually receive that request, you need to assess an accommodation. And how can you do that? It's by requesting medical information. Some employers may, as I've mentioned, just want to grant an accommodation request, but best practice in our view is not to do so. It's best to get information. The reason is twofold. On a practical basis, it's better to understand the nature of the request, and it'll help on a day-to-day implementation basis down the road, as I've spoken to earlier. But there's also, as we've talked about, the legal and procedural duty to accommodate, and the best way to engage with that process is by creating a paper trail. And to do that, you need to request medical information. And so, as employers have a duty to accommodate, it's also important to note that employees have a corresponding duty. They have a duty to cooperate and engage with the process. And to do that, they need to provide relevant information regarding their limitations. In the unionized workplace, there will be a third party that also has a duty. That would be the union, and they have a duty to facilitate. They're not permitted to impede on the employer's access to the relevant information. If an employee refuses to provide medical information, employers are allowed to discipline. It's important to note that the discipline as a best practice should be progressive discipline with warnings, and specifically to emphasize to the employee that the discipline is unrelated to their disability. It's not as retaliation for the request for an accommodation. The discipline is strictly because they're being insubordinate and not providing the employer with information to which they're entitled. But if an employee is willing to engage in the process and facilitate a medical request to their doctor, employers can ask for some information. The big warning to note is that employers are not entitled to request specific diagnosis information, but they can ask for other relevant information. And that would include the limitations that a doctor anticipates on the employer's ability to perform their duties, the prognosis about when the employee will be fit to return to their full duties without any limitations, and if the employee is on a leave, whether and when the employee could return to work in the foreseeable future. While an employer might ask for this information, unfortunately, in our experience, it's not uncommon for medical professionals to not provide detailed answers. Employers, in that case, should ask for clarifying questions. It shouldn't be a one and done scenario. If they need more relevant information, they should seek that and ask that to the doctor again. And if the doctor is continuing to not provide the relevant information, employers can also consider scheduling an independent medical examination. And speaking from our experience assisting clients, I can definitely say that getting info from doctors can sometimes be tricky. There's many reasons for this. Doctors are overworked. They may not answer questions in the exact way you want. They could give unclear information, and just generally, they don't want to write these notes. And as a result of this, there's actually been changes to the law. As of October 28th, 2024, employers are not permitted to request a doctor's note as evidence to an entitlement for an Employment Standards Act leave. Now, that sounds really significant, and it is, but employers should be aware of what the limitations of that prohibition are. Even with this change, employers can still request a doctor's note. It just has to be a doctor's note outside of the first 3 days in each calendar year that an employee takes for a sick leave. As a best practice, when requesting a doctor's note or additional medical information related to an accommodation, you should be specific. You should give the doctor context and details that they'll need to write this note. If you ask precise questions, it's really your best shot to get the doctor to cooperate. And if you're specific with the doctor in your request, at the very least, you've created a paper trail. And this goes back to the procedural duty to accommodate that I mentioned earlier. So with that, let's move on to some legal developments because we've covered the basics and we can talk about some encouraging decisions over the last 18 months that show employees have to participate in the accommodation process, as I've just addressed. So on your slides, you'll see the lease-in decision. Here, the duty to accommodate was technically not triggered in some aspects, and that's because the employer never was appropriately informed about the employee's need for an accommodation. The employee didn't make a further request for an accommodation, and they didn't engage in the process thoroughly. Some of the background facts of the case that I think are particularly useful to understand is that the employee was concussed at work. They were absent from the workplace and taken off the work schedule due to some scheduling uncertainty. They took a leave and returned to work, but later requested time off, which the employer granted for them to attend a doctor's appointment. After which they didn't return again, and they instead filed a discrimination claim with the Human Rights Tribunal of Ontario. The tribunal decision was favorable to employers. It stated that the employee in this entire accommodation process and during their various medical leaves, they didn't formally request an accommodation that the employer didn't provide. The employer asked for relevant details and additional information, but the employee provided incomplete information, and the details that they did provide didn't substantiate anything additional that they asked for, and they didn't ask for additional accommodations beyond what was provided. The employer was not expected to proactively guess if the employee wasn't going to participate. As I've also discussed, the standard for an accommodation is reasonable, but not necessarily the preferred accommodation. And that's the proposition that Eguele stands for. Here, an employer proposed an alternate accommodation arrangement that the tribunal deemed to be reasonable, even though it wasn't necessarily the employee's preference. But some background facts about the case here, the employee was a support worker and a single parent. The reason I mention this is because they have childcare responsibilities, and it's important to note that in the context of accommodation and the duty to accommodate applies for all grounds that are protected under Ontario's Human Rights Code. As we've talked about extensively, that involves disability, but it also protects family status. And while the case here in Eguele relates to family status, the analysis and the process of accommodation is all the same, and so the takeaways are just as valuable for employers. So when the employee here requested a shift change to not work on Saturdays and the request was denied, they filed an application with the Human Rights Tribunal and stating that they were discriminated against by their employer. During the accommodation process, the employee said the shift change was merely their preference, and they didn't explain that it related to family status. And this was key for the tribunal because the employee needs to provide all the relevant information for an employer to know what sort of accommodation to provide. Even though the employer didn't have all the information, they still proposed alternative arrangements. They were flexible, and the employee rejected these alternates without explaining that it had to do with their need for childcare. Given that the employer didn't have all the relevant information they asked for or needed, and so the alternates they suggested were deemed reasonable by the tribunal. An important additional detail about this decision is that the tribunal said the accommodation request wouldn't have been operationally feasible anyways. The employee was a support worker, and in that context, the specific type of shift change they asked for wouldn't have been able to be fulfilled by the organization. And it's interesting to compare the tribunal's note in Eguele to the Shabakshi decision you'll see below, where a request was similarly denied, but here a tribunal ordered an employer to pay $15,000 to an applicant. As I noted earlier in the presentation, the duty to accommodate applies to all aspects of the employment relationship. That includes a job applicant and even at the hiring stage. Here, the applicant had a disability and required a sign language interpreter for their interview. This was agreed upon by the parties, but the representative for the employer was for some reason shocked by this when they arrived for the interview and decided not to conduct the interview at all and not hire the job applicant. By refusing to conduct the interview, the tribunal deemed the employer's decision to be based on stereotypical assumptions about the applicant's communication skills, and it was deemed to be discriminatory. This relates to a lot of concepts we've talked about. There's obviously the duty to accommodate. The employer should have assessed more what forms of accommodation would have been feasible for them, but it also speaks to the bona fide occupational requirement, that legal threshold and test I discussed earlier. Here, the employer, given the nature of the prospective employee's role, they could have accommodated, but it's important for employers to note that accommodation isn't boundless. Employees cannot simply request anything, and employers have to accommodate. It has to be within the bounds of the necessary requirements for the role and the workplace expectations that are reasonable. So, considering these legal developments, we've learned a lot of information here, but we want to apply that now to remote work requests. It's, as Joel mentioned earlier, it's a hot button topic. We know that the knowledge we had before can really apply and be useful for employers here, and it's an ongoing issue because employees will frequently request them, and doctors are willing to assist with these requests and provide notes that specifically ask for a work from home arrangement. As we've talked about before, it's really important to request medical information, not just accept that first medical note if it's not detailed enough. The information you're asking for, it should determine or help the employer to determine whether work from home is appropriate or if an alternative can be provided. The information you receive, with that, you can assess the organizational context and assess the appropriate accommodation. For example, if the workplace limitation that you become aware of relates to the fact that an employee needs frequent breaks, they might not necessarily need to work from home. You can provide a quiet space in the office, for instance, and that might address the limitations the employee has without following the request exactly. There are other options as well. You can alter work hours, you can change their responsibilities, you can stagger their schedule, increase their break periods. All of these are ways to be flexible without necessarily granting the request to work from home. But there are some workplace limitations that do necessarily justify providing the accommodation to work from home. For example, if an employee can physically not commute to the workplace, it'll be much more difficult to assert that there's an alternative arrangement besides remote work. Overall, what you need to consider is whether the request is reasonable, is it connected to a workplace limitation, and does the medical information support the request? If the information doesn't support that request, employers are not obligated to provide remote working arrangements. You should still be flexible. You should consider other solutions. You should work with the employee because it's a collaborative process, but the employee's request by itself does not obligate an employer to provide it. Another key consideration is the operational impact of the request. We've talked about undue hardship. To reiterate and emphasize, because I can't emphasize it enough, it's a very high threshold to meet. But as a result of this high threshold, employers need to accept some disruption in some circumstances, and they might need to grant the request. The disruption itself, if it's minor or doesn't reach the level of being undue hardship, you won't reach that threshold. However, there are some jobs that really do need to be in person, while others can be performed remotely. If you think recently to COVID, a lot of jobs, the expectation was that they would be performed in person, and it was unimaginable that working from home could be possible. But many workplaces did shift remotely. And so if that position has worked from home in the past, it's going to be much more difficult for the organization to argue that undue hardship is established here. In the event that the organization is going to grant a request for a remote work arrangement, in our view, it's a best practice to continually reassess. The doctor's note might suggest, and this is something we've seen in our practice, to work from home for months or even for an indefinite period of time. And if that's the case, it's appropriate to reassess, ask for more updated medical information periodically, and you can ensure that the employee's current situation, the current limitations that they do have, reflect the accommodation that's been provided. The risk of not reassessing is that you might inadvertently create an expectation regarding the terms of employment that aren't based on accommodation, and the employee might be, as a result, permitted to work from home, even if their medical limitations don't support it. So with that, I'll pass it back to Joel here, and he can discuss the impact of tariffs on the workplace.
Thank you, Cooper, for all that information. Really valuable. I'm sure everyone has some useful information to take away from that. And I just can't help myself. I'm going to camp for just another moment on disability management before I shift over to the tariff discussion, because I'm sure I can't see you all right now. It is a webinar after all, but I'm sure that some of you, listening to that, hearing about asking for medical information, you're remembering circumstances where, you're requesting medical information from an employee's doctor. You're trying to do the right thing and you're just getting stonewalled. You're not getting the information that you need. And it's really difficult. It becomes frustrating. And the reality is, a lot of organizations where they get themselves into trouble is when you let that frustration lead you down the wrong path. Where you're not getting the information that you need from the doctor or the employee is not quite giving you the right information, and you decide, okay, well, if I'm not going to get the right information, I don't have to do it. And that's not the reality. That procedural accommodation duty that Cooper brought us through is really such an important one to bear in mind. I'll give you a recent example of an ongoing situation that Cooper and I are supporting one of our clients with, just to really help you understand. You're not alone when you're getting those challenging situations. This is a situation where an employee's been on leave for quite some time, years at this point, and it seems like the employee may not be able to come back to work. And so our client was requesting information to get an update. Is this person going to be able to come back to work in the foreseeable future? Because if not, maybe we are at that point of undue hardship and the related point of frustration of contract where the employer would be able to end that relationship, pay out what the employee may be entitled to, and they can move on their separate ways. And in that case, ultimately, after some requests, there was a medical note that made it very clear, yes, this employee is not going to be able to come back to work, for the foreseeable future. That is clear medically, and so that seemed straightforward. But along with that medical note came a covering letter from the doctor. On top of their own letter that was answering questions, they gave another letter, and the doctor said, this employee is really confident that they'll be able to return to work. And I believe them. I think they will be able to come back to work. Directly contradicting the letter in their own name that was enclosed with that same letter. And this is one of those situations Cooper talked about an IME, independent medical examination. That's one of those situations you may want to consider going that route. You still do have more avenues available when you're getting information that's that contradictory, or that's that unclear to be able to help you do what you need to do. Go to that independent examination, get the right information from someone who's an expert in really informing employers about how a disability impacts the work, so you can determine the right steps to take. With that, as I say, I couldn't help myself. I'm going to bring us on now to the discussion about tariffs and the economic downturn that we're seeing. So, I don't want to go through the history of tariffs in detail, but I do just want to level set for some of you who may have been taking the ostrich approach, sticking your head in the sand and just trying to avoid all the craziness in the news recently. In short, as I'm sure everyone is aware, after Trump came back into power a few months ago in the US, he started rolling out a whole bunch of tariffs against Canada, against other countries across the world. Really, most countries across the world are now facing some new tariffs from the US. Um, Canada has retaliated with some tariffs of its own in response, and there are quite a bit billions of dollars in tariff revenue being collected by both governments right now while we're working through this process. Ultimately, the U.S. has exempted most Canadian goods from import tariffs right now, in line with the existing free trade agreements that we do have, but is continuing to threaten that they're going to put more tariffs back in place. Canada has been holding off on certain tariffs, but still maintains some of the tariffs against the US. As it stands right now, the main tariffs in place against Canada are a 25% auto industry tariff, which Canada has retaliated with the same type of tariff against the US's auto industry, and steel and aluminum. We had a 25% tariff for a long time. Just this month, it's actually increased to a 50% tariff, which is devastating, I know, for a lot of our industries in Canada. We have got some promising news recently from the G7 just a few days ago. So the G7 that was held, there were some meetings between Canada and the US, and there was an agreement between Mark Carney and Trump that within 30 days there would be some sort of agreement or not, right? And then more tariffs may come if there's not an agreement. But the noise that the media has been reporting on has been that there's some good progress. It looks like we may get there. We'll see. I'll believe it when I see it. If I'm being honest with you, there's a lot of uncertainty going on, and it does seem like with this U.S. administration, the opinions and the decisions can change by the minute without any kind of clear reason as to why. And so, let's see if it happens, but let's be optimistic that that the governments are going to be able to work something out. With that said, whether or not something is worked out, we are seeing the impacts of this on our economy. I'm sure many of you in your organizations are starting to see this as well. I know from the not-for-profit sector, even a lot of nonprofits are having concerns about funding and potential funding freezes from the government as they're looking at what's the economy going to do. And of course, for-profit enterprises, corporations are going to have a lot of issues that a lot of you have been seeing. Some issues there, right? And consumers are spending less, businesses are spending less. The impacts of these tariffs are driving certain prices up, and that's going to continue to drive other prices up. There is a knock-on effect there, and what that's leading to is a recession. The economists have been calling for calling for a recession for some time, suggesting that that's to come. We're seeing unemployment go up, up, up these past few months. We're now at 7%. That's the highest that we've seen since 2016, outside of about a year period during the pandemic when that was a bit of a different situation. I think we can all agree. And so it's up and it's expected to go up further over the next few months. There was just a report yesterday that Deloitte's economists let out, and they were indicating that unemployment's going to go up to probably about 7.3% in the next few months from the 7 that it's already at now. And they're still predicting a recession in these next few months before things may turn around. That is going to have impacts on many employers. That's the unfortunate reality. I wish I could say, we're going to get through this and there's not going to be any impacts. There's probably going to be some impacts on a lot of you. That doesn't mean that you can't deal with them in some way, shape, or form, right? It wasn't long ago that employers were, really finding it hard to find any good talent because the job market was so strong. And certainly we're not at that level now with the unemployment rate going up. And we're at the point now where some organizations, have concerns about retaining your full workforce right now. And so, a lot of you may be asking, what if we lose all these people that we've invested so much in because we won't be able to retain them, we won't be able to keep paying them while we're working through this process. Um, it's a good question, and the reality is, in some cases there may need to be permanent, dismissals and permanent layoffs, and we'll talk about how you can try to protect against that as much as possible in a couple of minutes. But there are ways that you can try to get creative, prepare yourself, take advantage of opportunities that are there for you to try to protect against those permanent layoffs that can really impact, costs and your ongoing feasibility as an operation because, you lose your great talent. It's hard to get that talent back and retrained as the economy comes back up. So, what options are there available for you as employers in Ontario? Well, first of all, I just want to talk about some changes to government programs that are there to help work through some of this process. And they're both there to help employers, but they're also there to help employees who may be losing their jobs as well. First is the Employment Insurance Work Sharing Program. That's a federal government initiative. It's been in place for many years now. The idea under this program is that it allows, where there's a downturn in the economy and in sales, and so the employer can't retain all the hours of their employees that they may have had before that. Employees can come to an agreement with the employer where they all reduce their hours, and some of the hours that they're reduced will be in part compensated through EI payments by the government. And so that's been there for some time. It's something that certain industries do use habitually, those types of industries that do face economic shifts. The auto industry is one, even leaving aside the significant impact right now. It tends that in that industry, they'll need to staff up, staff back down, what have you, and work sharing can support those types of industries, in normal times as well. That program has now been expanded and made easier for employers to access during this period where we have this uncertainty with the tariff. So the government has acknowledged that there's some uncertainty, and they've tried to make it easier now to access this. And so, what's happening right now is that the government has extended the potential duration of a work sharing program from 6 months, 26 weeks, to almost a year and a half, 76 weeks. And so that's going to, help, set you up if you are going to face these downturns to take advantage of this program. There's also a shorter cooling down period between work sharing programs. And so, if you get to the end of a period and you still need to be part of that program, and you don't have to wait as long before you apply again and start benefiting from it again. The government's also made it easier for certain different employees and employers to access this program who may not have had access to it before, and they've extended these new rules until next March. And so that is a really useful program that's there. A lot of employers just don't know about it because if you're not in one of those industries that tends to benefit from this program, you may not really be aware that it exists. Take a look if it's one that might help your organization. It can really help you avoid those layoffs and potential dismissals because the government's helping keep your employees something close to whole if the hours are down for a period of time. In addition to that, For those who do need to just go outright lay off your employees, whether it's temporarily or permanently, there is a new program that the government has put in place to try to shift the way EI works, make it a little bit easier. Certain things that they've done there, EI benefits can be received by employees for up to 4 more weeks, depending on eligibility criteria. There's also a reduced number of minimum hours that employees need to have worked before they become eligible for EI, and so more employees who may be laid off will be eligible than they would have been before. And then some of the rules around the waiting period for EI benefits, how termination pay interacts with EI benefits have been shifted as well. And those are all making it easier for employees to access it. And with respect to the termination pay impact as well, there's some unique strategic things that employers can take advantage of if you're negotiating packages where you do have to let an employee go. That I recommend you get advice if that's something that you're looking at right now to see how that may help you. These are just a couple of the programs. There's a number of other things that our different levels of government have been putting in place. There's different loans, there's different grants, there's different tax relief measures that have been put in place from various different government bodies and organizations. CRA, Business Development Bank of Canada, Export Development Canada, the provincial government, provincial taxation. There's different organizations that are doing things to help. I encourage you, if you are facing the impacts of these tariffs and the economic downturn, take a look at those, see where those can help you work through this process to try to minimize, how many layoffs you may need to make, with the impact that it'll have on your operations. But, and unfortunately, there is a but here, layoffs may be necessary for some of you. Again, I don't want to sugarcoat that. That's just the reality that we're facing right now. And so, for those of you who may need to do temporary layoffs, you need to make sure that you understand how the rules apply in that way. A lot of employers have this misconception that if you need to temporarily lay somebody off, you just follow the rules in the Employment Standards Act and you're fine, you're allowed to do it. That is not the case. Employers do need to have a contractual right to lay an employee off. Most commonly, that's going to be in an employee's employment contract for non-union employees or the collective agreement for unionized employees. So take a look at those, determine whether you do have that right to lay off. If you don't, a temporary layoff, even if it complies with the Employment Standards Act, is going to be treated like a termination, and you're going to potentially owe that employee a lot of money. I'll talk about what that can look like in a second. And so be careful with that. Make sure you have the right to lay off. Even if you don't have the right to lay off, you can look at employment agreement updates now so that you do have that right going forward if you're not on the cusp of laying somebody off already. And even if you do have to lay off very shortly, you can ask the employee if they'll agree to a temporary layoff and have them sign off and agree to that as a one-off. There's certain technical things you need to do that, but that is achievable. And a lot of employees will agree to that because although obviously they would rather keep working and save their job permanently and at this time, if the difference is temporarily going away and coming back to the job that's there for them, a lot of them may prefer that, right? And so you can look at that kind of one-off agreement as well. And then when you are doing layoffs, make sure you're complying with the legislative rules. Layoffs can only be up to 13 weeks by default, unless certain things are done. The most common would be unless the employer has the employee on a benefits plan and the employer continues the employee's benefits during that layoff. In that case, the layoff can be up to 35 weeks within a 1 year period. And so, make sure you understand, what the rules are there. Make sure you determine that you have the right to do it before you take that step. But that is an avenue that you may be able to look at to avoid those terminations. Now, if you do need to look at terminations, you do need to, again, understand the rules around that. This is something that I've spoken to both of these organizations that are hosting us here today before. And so some of you may have heard about some of this. I don't want to spend a lot of time here in the interest of time to make sure we can get to the Q&A, but also just as some of you may know this, but I do want to make sure that you all have the general idea available to you. So in general, if an employee is being let go without cause, and a downsizing is the type of termination we're talking about here, that would always be without cause, the employee is going to be entitled to employment termination entitlements. The bare minimum is termination pay and severance pay, if eligible, under the Employment Standards Act. And so that can be significant. It can be up to 8 months of pay that an employee can be entitled to, depending on years of service. But that's just the bare minimum. And so union or non-union employees who are being let go permanently will be entitled to that bare minimum under the ESA. There's also mass termination rules. If you're letting go 50 or more employees within a 4-week period, employees are entitled to more than they would be otherwise. And so you want to look at those rules as well. Beyond those minimums, though, employees, especially non-unionized employees, will be entitled to more. They'll be entitled to common law reasonable notice. And that's a concept where the courts essentially award the employee pay in lieu of notice for however long the court believes it should take reasonably that employee to get another job. That notice period tends to be way longer than the statutory period. On the low end, 2 or 3 months for even a very short service employee of a few weeks. On the high end, 2 years, and in extraordinary circumstances, up to 2.5 years. So two and a half years of pay that we're talking about, a ton of compensation that you can owe employees. Whereas again, the Employment Standards Act entitlements max out at 8 months, and in many cases, it's going to be a lot less than that. If you're a smaller employer, they'll max out at only 8 weeks. So you're talking about a swing here of 8 weeks and 2.5 years for certain employees, depending on years of service and position and size of employer and some other factors. And so the way that you can try to limit those entitlements to those statutory entitlements that I'm talking about, the up to 8 weeks or up to 8 months, depending, is through a termination clause in an employment contract. If you have those, they really do help you, protect the organization against the incredible impacts of a termination. Because for some smaller organizations, you have some long service employees. A single termination can be too much to bear, especially when you're facing economic downturns more broadly. And so, you want to make sure that you do have these things in place. Now, when we're talking about termination clauses, it's really important to understand that the courts do not like to enforce them. Ontario's courts for the past 15 years, really they've been in a fight with employment lawyers who act for employers like Cooper and I do. And so essentially the courts keep finding new technical reasons to say a termination clause is not enforceable. The general rule for termination clauses is that they must in all circumstances comply with the Employment Standards Act. And if they don't, the courts won't enforce them, and instead the employee is entitled to common law notice. That seems simple, but again, the employees lawyers who act for employees keep on coming up with new arguments to say some technical reason why a termination clause that the courts in the past have always said is fine, that now say that that shouldn't be enforced because there's this reason why we can say that might not comply with the Employment Standards Act. And the courts are very receptive to that because the reality is, I think a lot of judges wouldn't say this, but the reality is, they want employees to get that default common law notice. And so they're going to hold employers to a very strict standard of compliance if they do want to rely on these clauses. And so we keep seeing big decisions where termination clauses that were fine one day are suddenly not fine because of a new decision from the courts. Back in 2020, there was a huge case called Waxdale that some of you may have heard about that rendered a ton of termination clauses that were in effect in the province overnight unenforceable. And then last year, 2024, another case called Dufo came out. Again, it rendered a whole bunch of termination clauses unenforceable overnight. And so if you haven't had your termination clauses reviewed since, before 2024 and certainly since before 2020, I strongly encourage you get those clauses reviewed to make sure that you have something that's compliant in place. It may have been compliant when it was drafted. It may not be compliant now. And in many cases, there's a good chance it won't be. And so you want to get those reviewed. And, if you do need to update those clauses so that you're protected as an organization, and if the worst does happen, you do have to let people go, that you know what you're paying and it's predictable and it's not that 2.5 years potentially. You want to make sure that you're getting them reviewed and updated before you're directly looking at those dismissals. Because if you've already made the decision you need to let somebody go, it's probably going to be too late to get that new termination clause in place. So, don't sit on this, don't wait. I really strongly encourage you to get advice and make sure that you have, enforceable agreements in place with enforceable clauses. And what you may have thought was enforceable recently may not be now. So make sure you're looking at that. I'll say there have been some recent wins for employers this year. There's been a couple of cases where our courts have actually enforced termination clauses, which shouldn't be all that exciting because, that's the whole point of the clause. But the reality is the way the courts have been moving, it is really, good news for employers. Hopefully that's going to move us more toward a common sense interpretation of these clauses going forward, but we're not there right now. And so make sure that you are getting them reviewed. So that brings us to our last couple of quick slides that I want to touch on, and then we can get into the Q&A. I know we're near time, and so as long as it works for Angelica, we're happy to stay on for an extra few minutes and answer some more questions if we have them. And a reminder now as well, if you do have some questions, you've been just trying to keep up with all the content we're covering here, and you haven't had a chance to put them in the Q&A box, please put them in there so we can make sure that we'll cover those for you. So when we're talking about takeaways, the first thing I like to do is talk about common pitfalls. What are some of the things that can commonly get employers into trouble? First one, granting or refusing an accommodation without getting the details. Cooper talked about it. I shared my story as well. I couldn't help myself. Make sure that you are meeting that procedural duty to accommodate, get the medical information that you need in order to accommodate. Without that, you may not have met your legal obligation, even if you give the employee the exact accommodation that they want. And also, you're in the dark about, what the reality is and what the relevant information is that would allow you to accommodate in the best way for you as an organization. Because, like Cooper said, accommodation must be reasonable, not perfect, not preferred for the employee. Beyond that, laying employees off without their agreement. I just talked about this. I won't camp on it for long. But if you don't have that contractual right to lay an employee off in the employment contract, in the union collective agreement, in a one-off agreement with the employee saying that you can lay them off, you don't have the right to do it. And laying a temporary layoff is not a temporary layoff as the law sees it. It's a permanent termination, and the termination payments flow with that. And then again, relying on an outdated termination clause. I can't tell you how many times organizations have called me, new clients reached out and say, I had a lawyer 5 years ago help me with these employment contracts. I put them in place. So I let this person go. I paid them what the termination clause says. And I got this weird letter from a lawyer, and they're asking for 10 times as much as what I paid the employee because, and why would they send this? I have a contract. The language is there. A lawyer helped me draft it. And like I was saying, the courts keep finding new ways to find those termination clauses not enforceable. I hate being the bearer of bad news for those organizations, but that's my job to do that, is to say, unfortunately, this clause may not be enforceable any longer because of these shifts in the law. And so making sure that you're up to date and that you've had those reviewed regularly is really important. And now is, as important of a time as any because of the reality of our economy right now. And finally, best practices. There are a few that I want to touch on here. You want to collaborate through the accommodation process. You have an obligation to be collaborative as an employer. Your employees have an obligation to be collaborative as well. Make sure that you're working together. Make sure you're getting the information. But as you go through that process, remember again, you just have to provide reasonable accommodation. Something that's not the employee's preference may still reasonably accommodate their limitations, but might work much better operationally, maybe much more affordable and reasonable for you as an organization because it may allow you to have the employee doing more of their role, making sure that more is being done. There's more cost savings there. That's okay. If it's a reasonable accommodation, that's the standard. Um, from there, another best practice is document, document, document. Cooper was talking about this as well. It's a crucial one that you need to do. Keep written records of accommodation efforts. Keep written records of the communications that you have with the employee. If they're not cooperating with you, keep those written records. Cooper brought you through those cases and told you about how those records were crucial. The employer asked the questions that they needed to in the Aguilera case. The employee did not cooperate, didn't give them the information that they were asking for, and so the employer didn't have a duty at that point to accommodate further because they didn't get the information that they needed. And had they not asked for that information, that case very well could have gone the other way. And also had they not documented it, had a record of asking, could have gone another way. Typically, although the law doesn't require things always to be documented, the reality is if it's not documented, you're going to have a harder time proving to a judge that it happened. Much harder time. And then just make sure that you're being proactive. Review your employment agreements, review your policies. When it comes to disability management, make sure you have a solid accommodation policy in place. The Human Rights Tribunal asks that on their human rights response form when someone files a claim against you. Do you have a policy? It's important. Make sure that you've got that in place and make sure you're getting your employment agreements updated as well to both give you that right to lay off, but also to give you that certainty and clarity around how much you would have to pay if, unfortunately, you do have to let someone go.